Hello. Hello. It's fine. Which Hello, good evening. Hello. Mic test 1, 2, 3.
Hello. Mic testing 1, 2, 3, 4. Hello.
Hello, check, mic check.
Hello. Mic testing 1, 2, 3, 4. Are you? Hello.
Hello, check. Hello, check. Hello, check. Hello, check. Hello, check. 1, 2, 3.
Hello. Mic check 1, 2, 3. Hello.
Hello, check. 1, 2. Hello. Hello, check. Hello, check. Mic testing. Hello, check. 1, 2. Hello, check. 1, 2. Hello, check, mic check. Hello, check. Hello, check. Hello, check, mic testing. Hello.
We can be seated.
Please sit down. Please be seated and keep your phones on silent. Good evening, everyone, and a very warm welcome to all our esteemed panelists and to our August gathering. We are here to witness the release of a book on a topic which has little or absolutely no material available in the public domain, especially in the context of India. The strength of this book lies in the fact that the author himself was the counsel in about 50% of the cases that are discussed in this book. So, a lot of first-hand understanding of the subject has been brought together for the very first time through this publication. Publishing is a painstaking process, which I'm sure the author must have realized. There have been deliberations and many back and forths, from reviews and feedback by a specialist editor, Mr. Neelkantan, to numerous queries via copy editors, citation checkers, and typesetters. The publication was a team effort which involved many intricacies. This year, I have completed 10 years in the field of publishing. Yet, my most favorite experience till date remains the same: watching an idea metamorphosize into a book. The first email with respect to this book landed in my inbox in the year May 2020. But deliberations on this work had started, in fact, in the year 2018. So it took roughly 6 years for this idea to turn into a book, which is before us today. Now that we have gathered to celebrate this book, I would like to felicitate our chief guests and our guests of honor. First, I would like to welcome our chief guest for the day, Justice Suryakant. Good evening, sir, and welcome. Justice Suryakant started his practice in Hisar way back in 1984 before he moved his practice to Punjab and Haryana High Court in the year 1985. In the year 2000, he was appointed as the youngest Advocate General of India and was designated as a senior advocate in the year 2001. He became a permanent judge of the Punjab and Haryana High Court in 2004 and later the Chief Justice of the Himachal Pradesh High Court. In the year 2019, he was elevated to become the judge of the Supreme Court and is slated to become the Chief Justice of the Supreme Court in November 2025. I would like to call upon Ms. Prachi Bharadwaj, our editor, to present a token of welcome to Justice Suryakant. Thank you, sir. Next, I would like to welcome Justice K.V. Vishwanathan. Justice Vishwanathan joined the bar in 1988 after completing his law degree from Coimbatore Law College. In 2009, he was designated as a senior advocate in the Supreme Court and went on to become the Additional Solicitor General in the year 2013. In 2023, he became the 10th member of the bar to be directly elevated to be appointed to the Supreme Court. I would like to make a special mention here. Justice Vishwanathan has also been part of the SEC editorial board, which has also published this book. As a counsel, Justice Vishwanathan was a part of notable judgments like matter of concerning recovery of illegal money in SEBI versus Sahara, and also Arushi Jain versus Union of India, which was a matter concerning high risk of exposure of doctors and medical professionals while treating COVID-19 patients. In these cases, he was a counsel, and he's also given certain important judgments, which I will skip for now. I would like to welcome Justice Bhumika Indolia to present a memento to Justice K.V. Vishwanathan. Next, I would like to welcome Justice Manmohan. Justice Manmohan was enrolled as an advocate in the year 1987 and was designated as a senior advocate in the year 2003. In 2008, he was appointed from the bar to the bench and became an additional judge of the Delhi High Court. In the year 2009, he became a permanent judge, and in 2023, he became the acting Chief Justice of the Delhi High Court. He has given many important judgments, including on the rights of the economically weaker sections to get support in case of chronic and critical medical conditions, and permitting children to use their mother's surname in legal documents that are considered pioneering precedents. I would like to call upon Priti Kumar, who will be presenting a token of welcome to Justice Manmohan. I would now like to welcome Justice Vibhu Bhakru for gracing us with his presence. Justice Bhakru is the chairperson of the Delhi International Arbitration Center. He enrolled as an advocate in the year 1990 and has practiced before various courts and tribunals in Delhi. He was designated as a senior advocate by the High Court of Delhi in 2011. In 2013, he was appointed as an additional judge, and he became the permanent judge of the Delhi High Court in the year 2015. He has given several important judgments on the infringement of trademarks and the discussion on what actually constitutes the infringement of trademarks. Other important cases include the use of trademarks as keywords in Google Ads program, whether that amounted to use under the provisions of the Trademarks Act of 1999. Now I would like to call upon Apurva Goyal to present a token of welcome to Justice Vibhu Bhakru. I would now like to welcome Mr. Vikram Chandra, who is our moderator for the evening. Mr. Chandra has been a student of Doon School, Delhi University, Stanford University, and Oxford University. He is a tech enthusiast and has co-anchored the popular tech show Gadget Guru on primetime television. He has also set up a multilingual video news platform named Editor G in the year 2018, positioning it as a disruptive offering in the digital news space. In the year 2000, he has also published a book titled The Srinagar Conspiracy. I would like to call upon Diksha Dabas to welcome Mr. Vikram Chandra. Next, I would like to welcome the man of the moment, the author himself, Mr. Chander M. Lall. Mr. Lall is a designated senior advocate practicing law largely in the Delhi High Court and the Supreme Court. He founded the firm Lall and Sethi in the year 1994 and has been consistently been recognized as a top-tier firm in India on IP law. He is the managing partner of this firm till 2017, when he was designated as a senior advocate. Currently, he is the only senior advocate designated who is a specialist in IP law. He has contributed to many publications, including trademark law and the internet and counterfeiting in the Asia Pacific. He is considered as an authority on IP law and has been the lead counsel in many path-breaking decisions on the subject. I would like to call upon Ms. Namrata Banerjee to present a token of welcome to Mr. Lall. Finally, I would like to introduce Mr. Sumit Malik, Established in the 1940s, EBC has been a pioneer in providing high-quality legal resources to professionals and students. Mr. Sumit Malik, as the director of EBC and the associate editor at SEC, has played a crucial role in advancing EBC's legacy to new heights with his visionary leadership. He has also pioneered the idea of SEC Times in order to provide the best analytical news without speculation, hush jobs, or rumor mongering. I like to call upon Ms. Anushka Basu, who will present a token of welcome to Mr. Sumit Malik. I would now like to call upon Mr. Sumit Malik to say a few words.
My Lord Justice Suryakant, my Lord Justice K.V. Vishwanathan, my Lord Justice Manmohan, my Lord Justice Vivu Bakru, Senior Advocate Chander M. Lall, Mr. Vikram Chandra, journalist and news anchor, judges, senior advocates, students, and gentle people. It is my privilege and pleasure to welcome all of you to this event where we will be celebrating the release of the book on the law relating to comparative advertisement by Mr. Chander Lall and the panel discussion that is to follow. I am grateful to our Chief Guest and our guests of honor for taking the time out to participate in this event. EBC's association with Mr. Lall begins with this book, and we welcome him to the pantheon of EBC authors. If you in the audience have attended some of our earlier book releases, you may have heard what I am about to say, but I say it again. In this new world of technology and artificial intelligence, ChatGPT, which allows for instant self-publishing and publishing on blogs, etc., the question is, how do we at EBC see ourselves? What is the role of a publisher? In today's context, I can say that we see ourselves as the trustee of the legacy of authors. We have, over the years, continued to preserve the legacy of authors, names that are synonyms with the study, teaching, and practice of law. Professor V.N. Shukla, Professor Kelkar, Dr. Avtar Singh, Professor Ahmed Siddiqui, Sri V.D. Mahajan, Sri V.G. Ramachandran, Professor T.K. Tope, Professor B.M. Gandhi, and others. And their books are revised at regular intervals. Using SEC Online, a user can, within seconds, bring out all the material related to comparative advertising. So when Mr. Lall and we spoke about publishing this book, the emphasis was not on the exhaustiveness of the material on comparative advertising, but a detailed analysis of what that material is. Add to the many years of Mr. Lall's experience at the bar and his deep insight in the very crucial area of this law, which affects such a large section of society. There was many a back and forth between him and us before the manuscript finally transformed into a book which is before you. A book, as I see it, is a custodian of thoughts and ideas, whereas judges, while deciding cases, are bound to decide the list before them on a given set of facts and apply the law to those facts. Authors, when writing books, do not face such limitations. Comparative advertising encompasses such fascinating facets of competing interests, protection of a brand or the image of a company versus the right to free speech. A good author will explain the law to their audience, but a great author will show the light forward by placing their thoughts and ideas in a book of what they consider the law ought to be. Mr. Lall has done that in his book, and we will be witness to a very interesting panel discussion later on in the program. As we at EBC enter our 82nd year since our incorporation, what we've learned to understand is what the legal profession requires and what our role can be in fulfilling that requirement. We believe that our role is to bridge the gap between legal information and knowledge and those who consume that legal information and knowledge. As a third-generation member of this publishing house, I've been blessed to be shown the way by my elders. My granduncle and grandfather had very humble beginnings, delivering books and bicycles to lawyers, including the great Mr. Ambedkar, when they started off as booksellers in 1942. But even then, the mission was clear: provide a service which will assist the practitioner in her work. The mission continued with the same spirit when EBC started publishing books for lawyers and students in 1947. The books we produce must necessarily be of very high quality and assist the user in their quest of knowledge. To be effective in our role, it is important that materials or content that we produce is authentic, accurate, and reliable. Also, we've continued to innovate over the years to keep ourselves relevant. In 1969, when Mr. Sren Malik graduated from Delhi University, having studied by the newly introduced case method, he realized that there was a need of faster reporting of Supreme Court judgments. Thus came about the innovation of SCC. All of you are aware that there can be no second edition of a law report, and it must be got right the first time. Prompt, accurate, and complete has been our philosophy, which we have adhered to since then, and we understand and recognize our responsibility that the honorable judges and bar rely on SEC. He has now taken up the onerous task of reporting judgments of the Supreme Court since 1950 till 1968, a period not covered in SEC earlier. Just in the first 10 volumes published, we have discovered and reported many important judgments of the court hereto never reported before. With High Court cases, or HCC, our newly launched venture, we begin the journey to report judgments of the High Courts of India with the same alacrity and comprehensiveness as we report the Supreme Court. Interestingly, we notice when reading judgments carefully that words like full scap have become full scrap and conjointly become co-jointly. EBC has recently welcomed Company Law Institute into its fold and now offering the famed income tax reports, ITR, company cases, and goods and services tax in both print and electronic to our subscribers. EBC was amongst the first publishers to introduce a legal research database on CD-ROM in 1996, which was less than 650 MB in size, and now the SEC Online Web Edition has grown to over 20 terabyte of data, 5.2 million documents, covering over 400 jurisdictions around the world. Even though we believe that the printed book is not going away, yet for the tech-savvy, EBC's EBC Reader platform is ready and has over 400 books, and we add new books every day. SEC Times, on which we report the happenings in courts, law schools, and the like, now has over a million views and 500,000 visitors every month. It is being relied on by an increasing number of legal professionals as their source for authentic and analytical legal news. Constantly innovating, EBC's newest services, EBC Learning, an e-learning platform, and Mercury, a judgment tracking software, are already gaining loyal users. We are fortunate to have as part of the EBC family a dedicated team of legal editors, software engineers, DTP staff, proofreaders, sales and marketing staff, and managers who, as much, if not sometimes, are more invested than us in ensuring that what is produced from the House of EBC is of high quality, accurate, and reliable. It is a wonderful experience working with you, Mr. Lall, on this book, and we look forward to his next book very soon. Thank you.
Thank you, Mr. Malik, for your address. I would now like to call upon Justice Suryakant to say a few words on the dais. Sir, please.
My esteemed colleague, Justice Viswanathan, Judge from Supreme Court of India, my former Chief Justice, Honorable Mr. Justice S.K. Kaul, former Judge Supreme Court of India, Chief Justice Manmohan, Justice Bakru, Mr. Chandramohan Lall, Mr. Vikram, Mr. Malik on the dais, my brother and sister judges from different high courts, honorable members of the bar, senior advocates, members of the legal fraternity. Till the time I entered Delhi High Court premises, I was not supposed to speak. Only while entering, I was told that I have to say a few words for 5 minutes. I was wondering that what should I, first of all, when we are going to discuss and have a question-answer interactive session, that what should I share with you? To be very frank, when Mr. Chandramohan Lall came to invite me for this event, I was really wondering that what is the concept of comparative advertising. Then I got the book and I tried to read and find out that what really it means. In a country like ours, where we have a fairly growing economy, where there is a huge wealth and market of consumers, I think this is an extremely important and crucial subject. Right from the judgment in Hamdard Khana to all the recent decisions, including, of course, the lead High Court in terms of the giving the judgment is Delhi High Court. And there is not much, I should say, jurisprudential growth as far as the Indian judiciary is concerned on this subject. But having regard to the importance of this subject, I said in the context of the Indian economy, the book by Mr. Chander Lall is really going to be quite invaluable guidance. The concept, as I could gather and trace out from all the judgments while referring to 19(1)(a) or eventually Article 21, or following the case law as it was developed by the American Supreme Court, probably the first judgment in Valentine something and then subsequent change in view by them, which also led to our Supreme Court also to deviate and take a slightly different view after Hamdard in Tata matter. I think ultimate central point is how to protect the consumer. So entire the concept of comparative advertising has to be consumer oriented, and that is why the principles laid down were that there should not be misinformation, deceptive, and concept is the advertisement must be honest. It can be comparative, but it should always be an honest advertisement. The disinformation, misinformation, and non-information, this has all been condemned and not to be treated as a permissible content of the comparative advertising. I am quite confident that the book authored by Mr. Lall will really respond to the needs of the hour. It will be a torchbearer, a guide for the judges, for the lawyers to develop the new jurisprudence, and in any case to be as competitive as the world in the concept of or in the field of the comparative advertising. And our courts, our judicial system also should not lag behind in any manner as compared to the other courts in developing this jurisprudence. We hope that today's discussion will also lead to that very object. Thank you very much. Thank you for giving this opportunity.
Thank you, Justice Suryakant, for your address and for your deep insights. We will now proceed with the release of the book. For that, first, I would like to request Mr. Suren Malik, Chief Editor of SSC, and Mr. Sumen Malik, CEO of SSC Online, to join the panelists on the stage for the release of the book. Panelists, please open the book in front of you. Please open the ribbon and release the book. This is indeed a momentous occasion and a matter of great celebration. I would now like to call upon Mr. Vikram Chandra to take over and to start with the panel discussion.
Thank you so much for that. And it's such a pleasure to be on the stage with some of the finest legal minds in the country. It's a real privilege to be here. However, I do have to begin by saying that when Chander Lall first contacted me and said he wished me to moderate this, a book on comparative advertising, I was horrified. When he told me it would involve a discussion around themes like Article 19.1 and Article 19.1 read with Article 19.1G, I was even more horrified. And when he told me that this was going to be happening with, as I said, four of some of the most profound legal minds in the country, I almost, dropped my phone in complete shock. What he then went on to convince me about was the fact that the whole purpose was to sort of explain some of these themes to a lot of people. In other words, my complete and total ignorance about the subject was actually a blessing, because I might be able to, ask some questions from a completely and totally non-legal and not technical mind. So I'm going to start off with that apology. Your Lordships, do please bear with me if I sound as if I know nothing at all about the subject or about law, because that is actually the correct position. But before I turn to all of you and start asking you some of the questions that do come up with this, Mr. Lall, why don't you start by elucidating a little bit? Seeing as you are the person, after all, who's written that much about it, you presumably know a little bit about this and what the issues are. So why don't you...
It's mostly ChatGPT, so I'm not sure.
But do help in dispelling some of the ignorance, and then I'll tell you whether something flickers, at least in my head or not, and then I'll put it to the poll, and if everyone has understood, that's great, otherwise we proceed.
Okay, so I do want to thank my panelists for being here. I know the exigencies of time that all our honorable judges have, so I'm very, very grateful that all of you have found the time to be here, including the honorable judges who are present here, so I did want to start with that, thanks. It's a very fun topic. It's not a difficult topic at all, and what better way to start it and explaining it in a simplistic way, Vikram, maybe that'll help you, is to start with a few ads and then just explain what a comparative advertisement is all about. So can we run the first ad? I just want to show you what this is what the book's all about. Can you run the ad?
फिर से बुला लिया मुझको। ये नहाता है ना रोज? हाँ, और नहाने के पानी में 2 ढक्कन एंटीसेप्टिक लिक्विड भी डालते हैं। आप भी नहाने में सिर्फ 2 ढक्कन, उससे बाल्टी तो बीमार नहीं पड़ेगी। पानी के कीटाणु शायद निकल जाएं, लेकिन बॉडी के ये यहाँ से यहाँ, फिर जुकाम, खांसी, फ्लू। तो नहाने में इससे बेटर ये लाइफ बॉय, एडवांस लाइफ बॉय, ये नहाते वक्त एंटीसेप्टिक लिक्विड से ज्यादा कीटाणु निकालता है। 10 इन्फेक्शंस वाले कीटाणु, 1 सुरक्षा, एडवांस लाइफ बॉय।
So this is clearly a comparative between, without naming Dettol antiseptic liquid and Lifebuoy. And it was found to be denigrating of antiseptic liquid. It didn't name the antiseptic liquid. And the interesting punchline was do dhakkan, which obviously has a double meaning. Aap bhi do dhakkan. And so when you see these ads, they look very innocuous at first instance, and nobody would say that it's denigrating anything, and probably half of you here, if I was to take a vote, would say, what's wrong with this ad? But if you see the identifiers, and this was Justice Gambhir's judgment, if you see the identifiers, there's a pan of a camera going to the medicines, because Dettol advertises that you should wash your toys with Dettol, so they showed toys. Then they showed medicines. Every second is crucial. So from toys, it went to medication, to a child who's repeatedly falling ill, to then the do dhakkan, to the misconception that if you put 2 dhakkan of Dettol in your bathing water, you have a full bath. Therefore, use Lifebuoy. So that's just one example of a comparative which was found to be denigrating despite not clearly identifying Dettol. We'll see another ad. So this will just give you the examples of what fun this form of law is. Can we run the next ad, please? Justice Bakru should see this carefully.
हो गया जाओ, आपने तो बोला था कैविटी टेस्ट होगा।
असली टेस्ट अब नहीं, तब करेंगे जब कैविटी का खतरा ज्यादा हो। वेट, करें टेस्ट। अभी भी कोलगेट स्ट्रॉन्ग टीथ के मुकाबले नया पेप्सोडेंट जोमी चेक दे 130% जर्म अटैक पावर और करे कैविटी वाले कीटाणुओं पर लगातार अटैक। तो अब क्या है बेटा? नया पेप्सोडेंट जोमी चेक कोलगेट के मुकाबले 130% जर्म अटैक पावर।
So far more direct. Why I said Justice Bakru should see this carefully, of course, is because he ruled on this as a division bench and reverted it back to the learned single judge to say that apply the correct tests. I'm not right now holding this to be denigrating. But here there was a clear comparison of two brands, which is permissible under law, and therefore Colgate and Pepsodent both were shown, unlike the first ad where Dettol was not shown. And therefore the question arose, is this disparagement or is this border on truth? So you're looking at one ad which didn't name the product and yet was found disparaging, and the other one which actually named and compared the two products, but the courts weren't sure that the line had been crossed. And I'm sure Justice Bakru will have more to say as when his turn comes in on this judgment, because I think this was one of his first judgments, and I think it's a very well-written judgment which is extensively discussed in my book. So it was reverted back, and there was also a print advertisement which was restrained, which had a similar message, but there the message was very clearly denigrating because it hid a lot of the material which the TVC showed. We'll just see a couple more ads, and then that'll give you an idea of what comparative advertising is all about. And Vikram, then I hope you will become the champion of comparative advertising and can ask the relevant questions.
Let's silence the comments and the compromises. Let's call out the hair removal creams that come in all sizes. Tall, thin, short, even the 10 and 20 gram sort. So open your eyes, read before use. Don't squeeze, don't spread, don't repeat the abuse. Urea and chemicals as strong as bathroom cleaners. Oh yes, hair removal creams are filled with it. So do yourself a favor, get some care for your curves. Cause it's love, not strong chemicals you deserve.
So this is wheat versus Gillette, where Gillette is putting through a clear message, and it's very subtle message of use of wheat has strong chemicals, equivalent to a bathroom cleaner because it's made by Reckitt, who also makes Harpic. So the message is very clear. The manufacturer of this wheat product also manufactures Harpic and probably uses chemicals as strong as Harpic has, which has hydrochloric acid incidentally, and therefore it's really bad for your skin. The Reckitt spatula is shown, not the branding, and then in the end, a removal of the wheat cream is shown from the screen, which was found to be by the Madras High Court to be denigrating. We'll see another ad.
Silence the comments and the compromises. Let's call out the hair removal creams that come in all sizes. Tall, thin, short, even the 10 and 20 gram sort. So open your eyes, read before use. Don't squeeze, don't spread, don't repeat the abuse. Urea and chemicals as strong as bathroom cleaners. Oh yes.
That was just to wake everybody up. It's all scripted.
ओ गॉड बचा लेना, नादान को अक्ल देना, हम सबको बचा लेना। दुआ की जरूरत पड़ेगी इस दवा के साथ। आम एंटीसेप्टिक साबुन त्वचा को रूखा कर देते हैं, जिससे दरारों में कीटाणु घुस जाते हैं। इसीलिए नया लाइफ बॉय स्किन गार्ड जो करे कीटाणुओं के वार और बनाए सुरक्षा की दीवार। बचा लेना डॉक्टर साहब, दुआ इनके लिए बचा लेना, हमें कोई डर नहीं। नया लाइफ बॉय स्किन गार्ड।
So again, the soap shown is a Dettol soap, which is shown as Sadharan soap, causing injury to your skin as compared to Lifebuoy, again held to be denigrating and a comparative ad. I think we have one more ad, or is... Sorry, that's it? So that just gives you a flavor of what the book deals with. All these ads and their storyboards are at the end of the book, so I think that helps to show it to the bench. But this is what it's all about, where The law permits you to make the comparison. You can even use the competitor's brand. And therefore, we also raise the issue, and the defense that normally comes up is that an advertisement is a 19(1)(a) right to freedom of speech. And therefore, restrictions have to be imposed within the limitations of 19(2). And one of the questions that will come up during this panel discussion is whether it should be freedom of speech, and is it entitled to the same level of speech as maybe what Vikram discusses in political speech, or as a speech for a journalist. Is it different from, I think that's the question that is going to beg an answer as we go forward in this subject. And I think this is a great panel for that discussion, Vikram, and that's why your relevance is, you are very relevant to this discussion, because you are an advocate of freedom of speech. You are dependent on freedom of speech for your profession. We are not so dependent as lawyers, because we may not handle these kind of cases, but your livelihood depends on freedom of speech. So take it from there. This is just to give everybody an idea that it's not such a complicated subject.
If I could just throw one more question at you before I move to the lordships. What exactly is it that the law says? What are you allowed to do and what are you not allowed to do?
So there is a line to be drawn. A, you can talk about yourself. You can speak as much as you want about yourself. I am the greatest, I am the best. The moment you start going into more specifics, if you start discussing in a car situation, I'm an automatic gear and you're a stick shift, that's fine, factually. But the moment you start talking about your competitor's product, that's where you're crossing the line. And then you start talking against. Are you
not allowed to mention it at all? Or can
no,
you
you can mention it, but provided you do it in a fashion which is more to puff yourself, to promote yourself, rather than denigrating. So if it's like any comparison between two people. You can speak about yourself and say I'm the best lawyer in the country, but you can't say so and so is not such a good lawyer. So, Akhil is one of the best that I know on the subject, and I am second to him. Now, Akhil, that's denigrating.
All right, great. Let me get in the lordships on this. So, Your Lordship, why don't I start with you? You're saying that you have written some of the judgments on this. So let's start with you, and I believe Chief Justice Manmohan, you also written a couple of judgments on this. If I could just ask you what you think, Justice Bakru, are some of the major issues in this?
On the ads?
On this entire subject of comparative advertising in particular.
Well, comparative advertising. Well, for one, comparative advertisement is permissible. I mean, that is obvious. On how the lines are to be drawn, well, I think Chander said it in brief. You can't be disparaging to someone. You can always have an hyperbole. You can always say that you're really good, but you can't really defame or denigrate another product. I think that's where the line is. On the question of how much puffery can you do, because invariably in a comparative advertisement, there is a certain amount of denigrating that you do to the product that you compare. That's obviously given. You're not going to put somebody else's product on your advertisement for the purpose of advertising that product. You're definitely advertising yours. So there is some amount of denigrating natural in this, in a comparative advertisement. But like I said, there is line. It's a very fact-specific decisions that are to be made. And it is when you look at an advertisement, courts have found that some of them cross the line, some of them don't. One of the areas I think they've been very sensitive about is if you are speaking as a matter of fact. If you were to, for example, give out very relevant statistics by saying my pH value of my product is X, it's 7, and the pH value of the next cream that is used is 8, and it's more acidic, and therefore use mine. That must necessarily have to be true. Because if it isn't, then obviously you've said something that is false, and that's really crossed the line way over. So really speaking, this is a very fact-sensitive decisions that are made. And the line, by and large, is just this, that you can say you're good, but don't say somebody is really bad in a comparative advertisement.
Chief Justice Manmohan, would you like to add to that?
Yes. Chander has argued a large number of matters on this issue. I lost most of them. The approach that I was taking in the matters when they were coming up before me was, that advertisement is a facet of free speech. And I was pitching it at Article 19(1)(a). And therefore, only the restrictions as could be envisaged under Article 19(2) could operate as restrictions. In fact, not to make it too technical, I'll just give a small instance. And that is where I was coming from when I was writing those judgments. It's in fact in a beautiful passage in a Barclays Bank judgment in the English courts. And they gave an instance. The instance was, if I remember correctly, that suppose there is a chocolate biscuit manufacturer and he wants to compare his product with the rival's product. So he publishes an ad and says that I offer the highest chocolate content in all the biscuits that are sold in the market. And my price is the lowest. And then he prepares a chart. In this chart, these two relevant material or verifiable aspects are mentioned. The person whose products have been compared hires Mr. Lall and comes to court and says, this is not truthful. His allegation is, yes, it has the highest chocolate content, it is the lowest priced, but it is not good for you because the calorific value in my biscuits is more, the fiber content is more. You have compared only two aspects, you have not compared the other two aspects which are also relevant. Now, is this disparaging? Is this denigrating? Is that not telling the full truth? Is there an onus to disclose everything on the person who's publishing the ad? And the spirit that was, followed by me at least in the judgments that I rendered, I think one was Havells and the other was Horlicks, was that, as long as you're comparing some material, relevant, verifiable, representative feature, you are allowed to blow your own trumpet. That's your strength. You're disclosing that to the public. When you say puffery is allowed, you are comparing it on some verifiable feature on which is your strength. So you mention that strength. For instance, I just asked him whether the Havells matter was over. He said, yes, it is over now, so I can mention it. See, they came out with an advertisement saying, our tube lights have the maximum lumen. And he said that is disparaging because his manufacturer was offering other features which had not been compared in that ad. So I said, this is a very viable, this is a representative feature which someone, while buying a tube light, may like to examine. For instance, some of the older people are suffering from cataract. They want a tube light which offers more lumens, which is more brighter. It's a verifiable feature. It may be someone is interested in that feature alone. So that injunction was refused there. So the intent is that it must be a verifiable feature that is done. For instance, let's take the case of cars. Someone may say that these two cars are being sold in the same segment. Same segment means, it's a van. Both are vans. The pricing is virtually more or less same. So someone says that my van is 15,000 rupees cheaper. So he wants to publish an ad saying my van is slightly cheaper. But the rival competitor says, but my van is cheaper to run, in the sense its mileage is better. That feature was not highlighted in the end. If that feature had been highlighted, then a proper decision could have been taken. So when you verify, the onus is to include all features. That the courts have said is not necessary, because what is your strength? That is buffering. That much is allowed in comparative advertisement. So the comparative advertisement is a very wide field. It cannot be disparaging. It cannot be untruthful. It cannot be misleading. But you can highlight your own features in that process.
I just wanted to add, and I think Justice Manmohan posed a very relevant question to me at that point. He says, tell me if I agree with you that only lumens has been 700 to 500, which is truthful. You say you are a CFL bulb, you are a LED bulb versus an LED bulb. Your prices are cheaper. You last 80 hours. So what am I supposed to do? List out all the aspects to compare with you, which a competitor must do. And if I list 8, there may be a 9th aspect. My bulb is square, not round. So I can't impose that on an advertiser to say that instead of highlighting one attribute of lumens, you must highlight 8. Then 8 will become 9. You will come after for a 9th. Then you will come after a 10th. So we'll just become courts where we'll be deciding these issues of who's better in an overall situation, and therefore it will be impossible for us to govern this, and it would really restrict his right to free speech.
But free speech apart, is truth an important aspect on this? And the reason I'm asking that is I've just spent 1 month on the election trail, and political advertising is somewhat different to commercial advertising. But truth quite often doesn't come into it. In media business, every single news channel says we are number one. They can't all be number one, but that happens. So is truth important or not?
So courts have, to my mind, very clearly said truth put in a wrongful way is not permissible. So pure truth represented in a way which is false will also be restrained, and falsity, of course, will be restrained, because Justice Lokur in Dabur versus Colortech said that untruthfulness will not be tolerated for a 19(1)A right.
All right. My Lord Justice Vishwanathan, let me get your thoughts on this, the entire issue.
See, Vikram, you must be wondering why all this debate. I think the reason is threefold.
Yeah.
One, as Chander points out, we'll get your point, but I'm just laying the background.
Yeah.
The money involved is so much. Because you see, the big FMCGs have huge market shares. And with the information explosion and the penetration, the speed with which disinformation can penetrate, market share can swing, can cause huge damage. That's on one side. The other side is the court's anxiety not to tread on the sensitive toe of free speech, because there is guaranteed to one party. We will get to the question whether it can be enforced against individuals in an action between two parties. Is it available? But court, after all, is a state, part of the state. While its orders can't be alleged to be violative of fundamental right, the orders that it passes, it has to keep in mind that. So the court is caught between not violating the free speech rights of a party, at the same time to prevent, an infringement. That is why all these tests are laid down, and we are trying to peg the threshold. Today, the threshold is pegged a little high because of the underlying element of free speech. That is why you have truth, if presented fairly, is fine. Puffery is fine. Comparison is also fine. Denigration is bad if it directly impinges on the product. So my own thoughts on this are that with the information explosion that is happening and the speed with which disinformation can penetrate, these tests are very important. But unfortunately, we don't look at ads normally anymore. As the advertisements were played, we were keenly looking at, no doubt as lawyers, where was the infringement? Early on, when life was less complicated, we had those nice taglines. I remember a couple of them. There was a tire company which came out with an ad. The tire that never tires. You see, it was a big hit. There was no disparagement. It was just, a puffery a bit. A dye company said, "We die for you. We die for you." But the problem is because of this huge competition that has taken place, and with ad agencies, coming up with peer pressure among, the executives also, pushing the frontiers. So with the result today, I'm sure Chander must be consulted. He must be telling them, "You try this. देखा जाएगा किसकी यहाँ लगता है." So there's scope for all this. There's scope for all this. So today is being pushed to the brink now. Brink, the frontier beyond which you can't transgress. On the line, just a few millimeters away. So I think it's an interesting question. It's a developing field, and as both Manmohan, Vibhu and Chander have said, these nuanced tests will keep getting evolved. But broadly, I think as Surikant said in his brief opening, ultimately the court will keep the interest of the consumer. Is he being misled? What is the test? The test of the common man? And as Justice Bakru said in one judgment, it could be several common men. There are several men on top of a Clapham omnibus. It's not just one. So unless you completely rule out that it can't be the view of a common man, the court will step in. And with the Indian Supreme Court having recognized commercial speech as part of free speech, I think it's become very challenging for the courts trying the suits, hearing an injunction application, from laying the threshold, and then, passing an order which would be in accordance with law and serve the ends of justice.
Justice Surikant, if I can take it forward, obviously the right to free speech, as we all know, is one of the most critical and the most foundational aspects in this country. But there are other rights, and there, from what I was understanding of this so far, there are challenges, there are questions between, right to free speech, what are the restrictions and limitations that can be put on it, how is it read together with the right to do business, how do all of these different contradictions get taken care of? So maybe we can ask all the others, but if you could just start with your thoughts on that.
I think, Vikram, it's a very important and very interesting question which you are asking. Well, as I was briefly pointing out at that time, to my mind, Tata Press judgment extended protection of 19(1)(a) to the comparative advertising, not only recognizing the right of the advertiser, that a commercial advertiser has also right to free speech or something, but very importantly, it was a corresponding duty and a condition. It was at a price that this right was granted. I am using the word. And that price was, as I said earlier, that consumer's right, and the judgment used the word, the right of the consumer in terms of be educated, informed and entertained. So the right of the consumer is extremely important, and therefore anything which must qualify or seek protection under 9(1)(a) necessarily will have to satisfy the conditions of 9(2) also, and beyond 9(2), to my mind, Article 21 also will play a very important role in the post-constitutional era. But sometimes I go even on the premise that if suppose there were no Article 21, what would have happened? Still, there were the civil laws, there are the law of tort, there are other provisions that you can't really, in the name of disparaging or in the name of condemning the others, you can't ultimately misinform and misguide the consumer. And therefore, that much protection will have to be extended at that condition in terms of the right to free speech under 19(1)(a) will always be guided, controlled by 19(2), 21 and other statutory provisions that may include whether Section 28 and 30 of the Trademark Act also. Having said that, I just want to add something a little more when I am expressing my concern about the consumer. You see, when I talk about the Indian society as a huge consumer society, let's also see that our consumer wealth is also divided in very different and distinct parts. You have a huge population of consumers in the rural areas, in the semi-urban areas. Their understanding, their informed knowledge about different products, depending upon the kind of requirements they have today and their capacity and capability to buy certain things, are altogether different as compared to the well-informed and a better informed consumer which you have in the urban areas. So therefore, when we extend or grant or protect this right under 19(1)(a), we also must always keep in mind to what extent we are, as my brother Viswanathan used the word, honestly, fairly, genuinely, bona fidely educating or informing, updating and educating that consumer. I think all these parameters need to be kept in mind.
Right. Chander, on some of the things that Justice Suryakant just said, how do all of these acts, I'm sure you've gone into this at great length in the book, how do all of these different aspects of the Constitution come in? And how does all of this tie in, for example, with Article 21, which if I remember rightly is the right to life and liberty?
Justice Suryakant gives an important example of the public interest. So 19(1)(a), which is right to free speech, is not only a right to speak, but also a right to receive. So if you're curtailing speech, then you're also curtailing the right to receipt of that speech. And at some point, Vikram, I'd like your inputs after you hear all our panelists on commercial advertising. How do you as a journalist view free speech from a political standpoint to speech on commerce? Should it be given the same level of protection? Hamdard said, perhaps not. Tata Press said, commercial speech must be given the same level of protection. The First Amendment of the US initially made no distinction between any form of free speech and then eventually said commercial speech is of a lesser species than political speech, because free speech essentially comes from a democratic society wanting information to be imparted to the people at large, and therefore you should not have the... And when you asked an important question about truthfulness, free speech does not require you to be truthful. It should be with reckless disregard to truth, is what is restrained, is when you've been reckless, because the US courts very categorically said that if truth was the requirement, then nobody would speak, because I would have to first verify it 10 times that was I speaking the truth, and I would have to think 10 times. So it's not about the truth. I could tell a lie or not the full truth, but it should not be with reckless disregard to the truth. So those are the elements, and I'd love to hear other panelists on this aspect of receipt of speech and how much is public interest that much important and how much is commercial interest of the, because also judgments talk about availability of paper. Press is dependent on advertising.
So press is dependent on advertising, but then frankly commerce is one aspect of it. And Justice Nathan, I'd also like to get your, on some of those themes that he said, are the two the same? Because the right to speech, the right to express yourself is one of the most foundational aspects of any democracy. If you can't speak your mind, what individual rights do you have? What civil liberties do you have? So it is an essential fundamental right. Should that same right be extended to a corporation which is essentially trying to make money or profits? Or should it not?
Yeah, I think courts have addressed this question, and I think they have harmonized it. They have harmonized it by saying that if the predominant activity is an activity which would need the protection of free speech, then they have applied and granted it the protection of free speech. So ultimately, I think it will depend on the nature of the advertisement, the activity, with an element of harmonizing not only the interstate rights available, and it should be available to corporates because corporates have shareholders. That's a view taken. I think just Manmohan took the view in the Delhi High Court, and the Supreme Court has said that as long as a shareholder or a director is implemented as a party in a writ petition, but it's presumed that the company, is represented by the members, and behind the veil are the members. So it is available to them. Also, Article 21, which is available to the citizens. So I think ultimately what's happening in this process is the doctrine of harmonious construction at work. If the predominant activity which is sought to be protected has an element of speech, and the speech needs to be protected, the court have not hesitated in extending 19(1)(a) by applying the dominant test. And also in case where the activity is purely, commercial, not so much of free speech involved, then they have applied the restrictions which are available in 19(6). But ultimately, there is a process, the cogitation of harmonization, which goes on inarticulately in the mind of the judge hearing the matter.
Justice Bakru, is there a difference between the right to free speech of an individual and the right for a corporation?
Well, as far as the Part 3 rights are concerned, like Justice Vishwanathan said, that even corporate citizenship is now accepted because you get a shareholder involved who then files a petition. Ultimately, he's carrying on his business through a corporate entity. So there is not, to that extent, the difference is a little short. But let me come back to one other aspect that was just highlighted. And that was a question that you say, how do you harmonize these two rights? There's a commercial right involved, there is a freedom of speech. So really a facet of Article 21, that is right to life, really. So if freedom of speech is so integral to that, to Article 21 as well. Well, one of the analysis that was done was that if you look at Article 21, it would have, especially in the right of privacy, would have about 4 facets. One could be a right of not anybody intruding on you. So there's to prevent intrusion. There could be another right to have privacy, saying right not to be defamed. Now that's another facet to the same right that we're talking about in privacy. And third, of course, would be right to prevent anybody from setting out in the public domain embarrassing facts. There may be facts, they may be true, but you still have a right to ensure that your defamation may be untrue, but even true facts should not come out. And the third, of course, are personality traits, for example. That is also read into the same aspect, which is the fourth aspect of this, which would be I must be allowed to make use of my own personality. Now these are mosaics that overlap. None of them really sit in silos that are away. So when you have to look at it, you have to step back. One of the good examples that I've found, which sort of intervenes this, was a case in England, in UK, of 2 famous actors, Michael Douglas and Catherine Zeta-Jones. They got married and they had an agreement with OK magazine that their wedding pictures will be only published in OK magazine. But then Hello magazine got hold of some of the photographs and they published it. And then, of course, Hello magazine was sued. So now the contention was, look, by publishing the wedding pictures, you have intrusions. It's an invasion into privacy. They're your wedding pictures. Why would you want a magazine to publish it who's done it unauthorizedly? The defense was very interesting of Hello magazine. They said, by entering into an agreement with another magazine, you already commercialized this aspect of your wedding pictures. So now we are only dealing with commercial rights. We are not looking into rights of privacy at all. Well, the case eventually got debated, turned on something else. It turned on the fact that in their contract with OK magazine, they still could select the photographs. So that was still held to be partly private. But if you look at these mosaic of rights, you'll find that what could have been absolutely Article 21, kosher to that extent, getting to the core by saying, yes, it's a right of privacy, you don't want intrusion, That's really an individual rights. And then you suddenly found a facet where they have been commercialized and was treated as a commercial asset. So it's really very fact dependent on which right would you consider as a primal right and which would you consider a peripheral right. Another example that comes very close to that is not an advertisement, is a famous passports case. Menaka Gandhi's case where the passport was cancelled. Of course, the Supreme Court had to then consider what is it? Is it Article 21? Or one of the arguments that raised was it could be a 19(1)A. The challenge was also laid on 19(1)A, that freedom of speech is being stifled. And in that context, some of the observations that were made by the Supreme Court were that, in fact, Justice Bhagwati, who spoke the majority, was that if somebody is really going out to make a dispatch and make a speech, then cancellation of passport would also affect 19(1)A. And this is just an example to show us that the rights that one talks about in Part 3 actually overlap. They're not really looked in as a singularly different right. And which particular right may be at a given point of time in a given facts primal and which may be peripheral, that will have to be determined on a very fact-specific basis.
Right. Sorry, we do have the benefit of one of the authors of Puttaswamy. Justice Lall is sitting right in front. And he put a very interesting twist to right of privacy, which was emanating from Article 21, to say that the mirror image of right of privacy is the right to publicity. And therefore, just as you have a right to be private, you have a right to publicize yourself. Justice Lall, would you like to comment a little bit on that, since we have the benefit of you being here?
Why don't I just come and hand you the mic?
No. We can't let you get away.
So, as you said, publicity and privacy are two aspects which are debated. We also debated the right to be forgotten in that. So, do you see the aspect of right to be forgotten as something when you want to withdraw from the right to publicize yourself? So, what has been pointing out in the panel is there are very peripheral sharp lines which get drawn. Where does it occur? Often, therefore, the judge who is judging it applies some yardsticks to these principles. And that's how I would look at it. And a lot of them have gone on the basis, as you said, that you were participant to more of those cases which did not go your way. There have been a liberal view towards not permitting disparagement of it, but publicizing yourself to an extent. That extent is the benchmark.
But in the Catherine Zeta-Jones example, would they be entitled to say that it is my right to publicity, I wish to publicize it through magazine A but not magazine B?
Yes,
and
so I would say that can you not have a passage for that publicity through A and not through B?
That's right.
That's how I would look at it.
Thank you. Sorry for taking you.
That's good. Justice Suryakant, if I could just come back to you. Talking about Article 19 or Article 21, it has to be said that, especially in the last a period of time, you're finding the right to free speech itself is coming under question, like for journalists and for others, but it's at a central level, district level. People are coming, they file FIRs, they file other stuff, checks are coming on what you're saying on social media and other things. So is if the right to free speech itself, even for the individual, is coming under increasing question, is that what we should worry about more, or the right of expression for a corporate? I mean, as a journalist, that's Chand, you were asking as a journalist, that's the obvious question to ask.
I think there cannot be any second opinion that right to free speech need to be jealously protected, and we must also take all measures to promote that right. There may be some direct, indirect attempts in different ways, because it's an innovative world, and people keep on inventing different kind of methods, mechanisms, sometimes misuse and sometimes otherwise, maybe lawfully, that they try to trample with this right. But I think the system as such, it's not only the constitutional guarantee, but also as a part of the right to live a dignified life, even that also includes right to speech, and therefore, particularly for the journalist and for the media, that right should remain protected and subject to whatever constitutional restrictions and which are qualified as reasonable restrictions. Beyond that, the right must be protected, and much, of course, depends upon case to case also. Sometimes we find that, well, it may qualify within reasonable restriction. There, those have been upheld also. But oftenly, when it is found that, yes, in the name of reasonable restriction, there is an attempt to gag, I think those gag orders also, we can say proudly, those have met their own fate. And at least the judicial system has not, rather I would say, has strongly disapproved that.
Sorry, Justice Vishwanathan.
I think a very important aspect mentioned by Justice Surikant just now, that there are innovative methods invented to have, it has happened. See, the classic case which you mentioned, a straightforward gag or an arrest for an article written, clear tests, unless it incites violence, mere advocacy will not be proscribed. But the Taros in Bennett Coleman, they never did anything about free speech. They just increased the duty on newsprint. The effect of it was the newspapers were suffering. Court came in and said, we look at the substance of the infringement, not the form. And they struck it down, tracing it to free speech. So corporates were protected when these indirect, innovative, as was mentioned, these have happened, these have been attempted, they will continue to happen, and the courts would surely play a creative role in protecting the rights within the four corners of the Constitution.
Right. Justice Manmohan, I have to get your views on this entire subject and where the difference between individuals and corporates come in, not least because Justice Manmohan's wife and I began our journalistic careers together. At that time, 30 years ago, it used to be, the restrictions are more from the point of view of somebody coming with a lathi, and now it's a bit more innovative.
You must be wrong. Nutan is not 30 years old.
Well, I learned a lot of my journalism from Nutan.
Certainly free speech is at the highest pedestal. And the main issue about freedom of speech is that there must be freedom after speech. And I think that's very important. As far as the commercial free speech is concerned, see, everyone has a right to promote his product. What is the advertisement meant for? It is meant to promote your product. So therefore, you are entitled to promote it, you are entitled to indulge in puffery, you can say I'm the best, and you can rely on certain standards on which you can compare, as I said. In fact, one of the interesting arguments made in one of the matters by Mr. Chander Lall was that in view of Puttuswamy's judgment, he is entitled to privacy to the extent that the rival cannot mention his name and cannot take the features of his product and compare them. But that argument I did not accept on the ground that, see, it cannot be against, right to privacy cannot be asserted against information that is already in the public domain. The rival's product is in the public domain, and one of the facets of free speech is that the consumer has the right to know. Why should his right to know by way of a comparative advertisement be stifled? And when he is doing it on certain bona fide, verifiable, representative features, it's not something that he is making out of his hat. These are genuine, verifiable features on which a consumer may take an informed decision. For instance, we saw that, I gave you that illustration of that chocolate biscuit having the highest chocolate content. Someone may be looking for the highest chocolate content in a product. He's not looking for the calorific value and the fiber content. So it's a verifiable feature. You're entitled to propagate that. That is free speech. And right of privacy cannot mean that these sort of features cannot be compared.
I'm conscious that we are running out of time, so Chander, maybe a quick last word from everyone.
I'm very tempted because I see at least 2 honorable judges and a very prominent counsel here who's handled a lot of these cases. If I could have a few words from them, Justice Chander, Justice Pratibha Singh, and Akhil. These are 3 people who I think have contributed tremendously on this subject, and we would be missing out on a good opportunity if we wouldn't hear from them. So, if that's all right to hold you out in this. Justice Chander, you've written at least 3 judgments. Justice Pratibha Singh has just written 1. Akhil, you've argued many and won against me in most.
Well, trust Chander to catch you by surprise. Yes, he's right. I've written a couple of judgments, and one of them was Coltrek, Dower versus. Sorry. I think if I'm not mistaken, I'm not very good with the titles of the decisions that I render, but I think this was one of those Odomos cases, which went up in appeal to Justice Lokur, and he actually expanded the test. That's right. And he brought in Article 19. So I was dealing with, the court was actually very conservative to start with, and I had about 5 to 6 precedents which didn't allow me the leeway, but I did sort of took that leap. And one of the things that I wanted panelists actually to discuss is that this is a very creative field. When you tamp down an advertisement, you are actually, sort of stemming creativity also in a sense. So often, if you would see these ads, they give a message which is full of sarcasm, humor, and it's been my approach that if you can give them leeway, you should, unless you cross the red line. So this was the Scream where they were ridiculing, in a sense, this is what the plaintiff was saying, that that Odomos cream is sticky, etc., etc. The other one said, no, nothing of this kind. So humor and creativity is one thing that I think judges should bear in mind and allow for that, because otherwise there are a lot of people who get affected. That's one. Since the discussion veered to free speech, and especially for journalists, Chander, you should remember that there are 2 important cases. One is of the US Supreme Court, and the other is the Indian Supreme Court, which is New York Times versus Sullivan, where the supporters of Dr. Martin Luther King published full-page ads about the Montgomery police commissioner because they were very unhappy with the way black Americans were being dealt with. But the ad contained a lot of factual inaccuracies. Justice Brennan said, in fact, in a sense, stopped public officials from suing the newspaper, saying a certain amount of leeway is required. You do not need to be completely accurate. Breathing space. Yeah, you need breathing space. And that's an important test. So when journalists report, since we are on free speech, you go by your sources. They could be accurate, they could be inaccurate. But that's not the reason to tamp down on free speech. Rajgopal followed the same Sullivan principle, where, what was that, Otto Shankar. He was this person who had killed a lot of people. So he had left behind a diary which was published by newspapers. The police came to the court and said, listen, all this is inaccurate. But the Supreme Court followed the Sullivan test and they said that you cannot tamp down on free speech. These are 2 important tests that the Supreme Court has followed, and we need to keep that in mind. Creativity being one of them. That's mine.
So Dabur Color Tech is what you wrote, and then Justice Lokur confirmed that, and that is the case on comparative today, the lead case on comparative. And the American case is the one where it said reckless disregard of truth and not truth.
And Rajgopal was public officials. They made a separate test. They also followed the Seymour Hersh's case, where I think one of our prime ministers had sued. Unless it is rash in the context of public officials, I think Justice Vishwanathan was not the test that they followed. Yeah. They said you can be. They gave a little. Genuinely.
I just want to say a couple of sentences. First thing is, one of the earliest cases which we did was the Cola Wars, Pepsi versus Coca-Cola, where Coca-Cola said Pepsi is bachcho wali hai. So that was like in late 90s. But two things. One is the best feature of this book was the addition of the storyboards of all the advertisements at the end of the book, which makes it so live for all the readers to actually see what are the scenes and how it played out in the commercial. And over these years, I can only say that Mr. Chander Lall has a patent on comparative advertising.
Akhil. In fact, I used to ask Chander, whenever he would mention a new matter, is your budget exhausted for comparative advertisement or not?
So, Chander, a question for you, and of course, any of the panelists if they want to jump in. And it's about where this line is drawn. Now, you started by saying that you're free to declare that you're the best lawyer, something you often tell me. No problem with that. But
Akhil, he told me when it came to modesty, he was second to none.
And you also said that
untruthful,
untruthful. You're crossing the line. You also said that you'll have crossed the Lakshman Rekha if you say Akhil is not such a good lawyer. Something I've occasionally hear you say.
Akhil causes distress to judges.
So that'll be different. Now the part of the reason that it's okay to say you're the best is because it's the realm of opinion. Courts cannot go into whether in fact you're the best, and the consumer understands that there's a degree of hyperbole, exaggeration, puffery, which is inherent in advertising. So why is it then that you can't say that somebody is bad? And why doesn't it fall within the same realm of opinion? In the political arena, when we're talking about free speech, you can openly say somebody is bad. Now, if you present a false fact about somebody, if you falsely denigrate somebody, that's a no-brainer. If the consumer is presented with a falsehood, which is objectively ascertainable, or with something which purports to be an objective fact and is false, then clearly that's crossing the Lakshman Rekha. But if you say that the other guy is bad as a matter of opinion, why does that cross the Lakshman Rekha?
So you're really talking of the reverse of puff. So you're saying if I'm allowed to puff and say I'm the best, why can't I say you are not? Because I think the law very clearly says while you are allowed to talk about yourself, if we allow you to talk about somebody else, then you're entering into a realm where you will always make. But surely if you are bad on as an example on Justice Manmohan's judgment on the lumens, so on lumens 700 and 500, so you are bad because you have 500 lumens versus 700 lumens, or you don't have the same chocolate content, so you're bad. I think that may pass the muster. But if you generally say you're bad, which you frequently, I've overheard you say that I'm a really bad lawyer, and I really think that that's crossing the line, Akhil, and next time if I punch you in the nose, that's interim relief straight there.
I'm sure you're going to preach a couple of other aspects of the IPC, which if you were to punch him in the nose. But if I could just ask one more, sort of legal or technical question before we start wrapping this. The entire question, Justice Suryakant, on, at the end of the day, fundamental rights, are they only enforceable against a state? How are they enforceable against a corporation? Doesn't that factor come into this?
I think looks to be a ticklish question that how to enforce the fundamental rights against private entities. But the way the jurisprudence is growing and people, citizens' rights are expanding even beyond the constitutional framework also, and by giving very expensive meaning to different fundamental rights also, when we are enhancing the entitlements, I think there should not be any difficulty, because where the individuals or entities are also performing a state act, I'm using the word, acting like a state authority, or if the degree of damage by them to somebody's fundamental right is equivalent to which the constitution makers apprehended from the state, I think the courts will find out their own innovative jurisprudential tools to protect even against these private entities also. And particularly in these matters, there should not be a difficulty when, say kind of a suit in terms of the provisions of the Trademark Act, or in a general suit where injunction is sought against someone, the courts can always, the parties are individual private entities, but there is nothing which to prevent the court to follow the principles or the analogy of the constitutional or fundamental rights, and then inject a party wherever it is found that somebody has crossed the Lakshman Rekha.
Justice Vishwanathan, you want to add something to that?
Yeah, I think today we have come to a stage where many of these fundamental rights have been held to be horizontal in their application, in the sense that it applies across the board. Initially we thought untouchability was a horizontal application. 21, it applied a horizontal sense, but recently we had a pronouncement in Kaushal Kumar's case, I think, Kaushal Kumar, where the court traced the jurisprudence on environment, public tort, and said that there could be situations where you could enforce it against non-state actors as far as the respondents were concerned. But as far as the citizenry is concerned, I told you earlier that initially there was a view that 19 itself was confined to citizens. I think the State Trading Corporation had taken a view. But then there has been dilution of that, because there is a shareholder, a director who is involved, and they are behind the company. But more importantly, as Justice Surikant said, see, we should not forget that the court is also a state. Its orders cannot be assailed on the ground of violation of fundamental rights, because they only declare the law. But as a state, it has an obligation to guarantee that it keeps in mind the fundamental rights available to parties. And I think that is where all this nuanced debate as to where to draw the difficult line has arisen. The 19.1a, the 19.1g, the 21. So that has caused the issue. So I don't think it could be argued anymore that in a suit between two individuals, the court can't calibrate it from the angle of the available fundamental rights. After all, what are fundamental rights? They are not conferred by the Constitution. They are only recognized by the Constitution. Basically, these are human rights. So even if you are not to have Part 3, we have Part 3, fortunately, because there is a limitation of the legislative power. Minority rights are put behind the ken of the majority. But except for those rights which are conferred, most of these rights could be read as part of human rights. Even minority rights by a broad interpretation. So these are already available. Free speech is a basic right, as you said, to realize the full personality. What is life without be able to speak freely? And Manmohan rightly said, freedom after the speech.
That's the
so I think we are well past that hurdle now.
I think we are out of time. Justice Bakru, if I could get some final thoughts from you and from everyone else.
Just on what this was said, what Justice Vishwanathan said about horizontal rights. Yes, it is important to recognize it. Constitution only recognizes it. Now, there may be difference in public law remedies and private law remedies. So you may not be able to file a writ petition, for instance, under Article 226 or 32 against your competitor by saying that he's put out an ad which is which is denigrating to my product, that remedy may not be available, but the right still exists. The right will be recognized in another forum. The remedy may be different. I mean, in fact, when the question came, one of the famous judgments that we have is ADM Jabalpur, the dissenting note in ADM Jabalpur, where Article 21 was suspended during emergency. Justice Khanna went a step further and said, assuming there was not Article 21, could you still incarcerate somebody without reason, without giving him a chance to deal with it? So the fact that rights exist is one aspect. How do you enforce them is another. So it's possible that you don't have to necessarily go and resort to public remedies which are available largely against state. But the rights would obviously be enforced otherwise as well.
All right. Justice Manmohan, last word from you.
I agree with what Justice Suryakant, Justice Vishwanath and Justice Bakru have said, that the fundamental rights are natural rights. They're virtually inalienable, and therefore they can be asserted even against private parties. Today, with the state virtually washing its hands off and allowing the private sector to take up the functions which they were previously discharging, these rights will have to be asserted against the private individuals also. And the argument can be that the state must ensure that my rights are protected, my fundamental rights are protected, and therefore it must ensure that the private citizens also follow those rights. Moreover, in a suit, there is no prohibition that you cannot assert fundamental rights or that the fundamental rights are confined to be agitated only in a 226, 227 proceeding. They can be agitated in a suit also. And replying to what Mr. Akhil Sibal said with regard to someone calling him a bad lawyer, he would have a right to sue. He would have a right to sue for defamation, to seek an injunction. Because if he can, because those are palpably false facts. If someone indulges in falsification and indulges in slander, surely you will have a right to get an injunction and file a defamation suit. So it's not that one is remediless. One crosses the boundary, crosses the red line, there is a remedy provided.
Mr. Lall, last word from you.
Well,
Before
we do wrap up, I just want a 2-minute thank you job for some of the people who helped me with this book, since it is about the book. I do want to recognize my colleague Nancy Roy here, because we spent last 10 years, almost every case that I prepared at Lall and Sethi, and subsequently I've argued. I don't know if Rajesh Jha is here, who's with Reckitt, who really, I mean, every case now that I argue before courts, look at this Reckitt, they are always a party to it. And Reckitt is why 40% of the cases in this book are my cases, because Reckitt had that faith in me to argue that. I also want to recognize Ananya, who's sitting here, who then took over the baton from Nancy, who helped me out with writing this book. Of course, there were several who came. I must recognize my wife and my son. I would go back home and show them those ads. Ishan is here, my lovely wife is here. Of course, the lovely flower arrangements are hers as well. I walked in, I'm like, wow. So every time I went back home with an ad which Nancy brought to me, and I was like, are you serious, taking this to court? And I would bounce it off the dinner table and get some ideas from that. From an organizational standpoint, I do want to thank Rohtas Singh ji, who's always been fabulous in arranging all of this. And once again, from the bottom of my heart, Justice Suryakant, I can't tell you, sir, how important this was to me. Justice Vishwanathan, thank you so much. Justice Manmohan, thank you for encouraging me. Justice Bakru, I really appreciate it. And I would be failing in my duty to say Sumit for taking this on to an author who you didn't know. I'm sorry, I did often thrash your brother in squash. And that's when the first conversation took place. And interestingly, I just noticed an email at our exchange in 2020 to say my book is ready. And I think we should publish it, and we are into 2024. And another junior of mine, Adab, who's here, who said 15 years ago, you started writing this book, and I put it in my CV 1 year, then CV in the second year, CV in the third year, then I said, forget it, this book is not seeing the light of day. So it's taken me 15 good years to finish this book. And I can't tell you, the labor pains are over, the baby is here, and I'm presenting the baby to all of you, and I hope you all enjoy this absolute labor of love. And now whenever I meet an author, I will touch his feet because I know the amount of, Pratibha, you're sitting here. You've just written a massive book on patents, which is decorated on so great respect for authors, including myself now. So I'll put that in. But thank you very much for all of you for coming here and gracing this occasion. It means a lot to me, to each one of you who's here, the honorable judges who've taken out their valuable time to be here with me. Thank you very much.
Thank you, panelists. This was indeed a very enthralling discussion which involved not just the panelists on the stage, but also quite an active participation from the esteemed guests in the audience. In the beginning, the audience got a first-hand understanding of comparative advertising by the playing of the ads and the explanation that was given by the author. To sum up the discussion, as Justice Suryakant said, that the ultimate goal of this branch of law is that the consumer should not be misguided. There were also other interesting discussions on free speech, that, for example, that if absolute truth was the only requirement, then nobody will be able to speak freely. And therefore, one should be able to speak, but there should not be an absolute disregard to the truth. Among other interesting takes and nuances by the panelists and the esteemed guests in the audience. But now I would like to formally bring the program to an end by calling Ms. Prachi Bharadwaj. She would like to give the vote of thanks.
Thank you, Nilofer. Good evening, everyone. Renowned writer William Arthur Ward once said, "Feeling gratitude and not expressing it is like wrapping a gift and not presenting it." And I simply cannot contain my appreciation for each and every one of you. First and foremost, let us give a round of applause to our esteemed chief guests and guests of honor, Justice Suryakant, Justice Vishwanathan, Justice Manmohan, and Justice Bakru. We are truly humbled by your willingness to take out time for us today. Next, I would like to extend my sincere appreciation to our moderator, the distinguished Mr. Vikram Chandra. Your ability to steer the panel discussion with such eloquence and insight has truly elevated this to new heights. I would also like to thank Justice Kaul, Justice Chander, Justice Pratibha Singh, and Mr. Akil Sibal for joining us in the discussion and taking it to another height. And of course, how can we forget the brilliant mind behind this insightful book, Mr. Chander Lall. Your work is sure to inspire and enlighten the legal professionals and laymen alike. We would also like to thank Justice Sanjeev Khanna, Judge, Supreme Court of India, for writing a thoughtful foreword for the book, and Justice Madan B. Lokur, Justice S. Ravinpat, and Justice Vibhu Bakru for their insightful and encouraging special messages. Their words have truly enriched this publication. To the tireless team at EBC, the legal editors, the copy editors, proofreaders, and typesetters, their dedication and meticulous efforts have been instrumental in bringing this publication to life. Our heartfelt gratitude also goes out to the production team and the press who have ensured the exceptional quality of printing and binding that we see before us. To the sales and marketing team, we extend our sincere appreciation for their role in taking this book to the wider audience it deserves. We would also like to express our gratitude to all the media houses for covering the event, Rohtas ji and the DIAC team for helping us in organizing the event, the organizing team, Bhumika Indulia, Nilofer Bhateja, Kriti Kumar, Apurva Goyal, Diksha Dabas, Namrata Banerjee, Anushka Basu, Shubhra Venkat, Tanmay Dhiman, Sachi Singh, Tejaswini Mishra, Amit Tiwari, and Sanjay Suman, who have worked tirelessly alongside me to bring this event to life. At last, but certainly not the least, I would like to extend my heartfelt thanks to all of you for turning out today and making this event a big success. With this, I would like to declare the end of this event. I would request you all to please join us for a wonderful high tea where we can continue to celebrate this momentous occasion. Thank you all once again and have a wonderful evening ahead.
Most hard work was thank you. I told you, बजाते हैं तो please join us for tea.